Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning, all. Thank you for coming. I am Judge Faruya, and to my right is Judge Campbell. To my left is Judge McMurdy, and we are here for oral argument in our case number TX 21-0009, ADP LLC versus ADOR and the City of Phoenix. As you may know, we record and live stream these proceedings, so please give your name and the name of your client before you proceed. You have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require you to keep track of your own time, and the clocks on the podium reflect your total remaining minutes, including the amount of time you would like to reserve. So if you'd like to reserve, please pay attention to the clock. Please keep in mind we have read the briefing, we have studied the record, and discussed this case in conference. And with that in mind, you may proceed, Counselor.
Good morning, Your Honors. Leslie Sorensen on behalf of ADP LLC, and may it please the Court. This case is about an overzealous interpretation of statute by a state agency that results in the usurpation of the legislature's authority to impose taxes. ADOR requires that you stretch, strain, and struggle to find a lease or a rental of software as a service. ADP's ask is simple. The taxing structure as to SaaS is ambiguous, and the matter should essentially be remanded back to the Arizona legislature for them to clarify whether TPT applies to software as a service. That notwithstanding, ADP is not in the business of leasing or renting tangible personal property.
You say that, and yet, I mean, what is the name of the document that you use to regulate access to e-time?
The contract between the county and ADP.
Mm-hmm.
It is a contract for HR and payroll services.
Is not a licensing agreement part of that suite of documents that ADP is requiring its customers to sign?
There obviously is a component where e-time is used as the software vehicle that goes to the contracted for HR services and payroll services. So it's actually a services agreement, a services contract. And I can point you into the record where the appendix that shows the list of the services that are provided under the contract.
But you don't disagree that one of the documents that is in play here is a licensing agreement, correct?
Your Honor, there is a licensing component, but I don't believe that the license that might be given over to the county from ADP amounts to the exclusive use and control requirements that are part of Arizona's case law. So while there may be a licensing component, there are so many other aspects of that software that is reserved for ADP that are not granted over to the county that it does not meet the exclusive use and exclusive control requirements that is necessary to have a lease or rental under Arizona law.
So help me understand this. The argument here is that because that you're referring to, it's in the briefing, and it talks about how because the county nor the city nor ADOR can modify e-time's code, that the use is not exclusive. Is that a fair summation of the position?
The inability, Your Honor, to modify the code is certainly one aspect, one indicia of what ADP has reserved to itself. However, there are a number of other ways in which ADP fully controls and possesses the software and does not turn over that possession or control to the county. It does all of the maintenance and updates. It does all the security patches. That ADP retains control over any customizations that might occur for different clients. So ADP owns all of the servers that the e-time is housed on. E-time itself never comes into the state of Arizona because the servers are housed outside of Arizona. So there are all of these indicia of control that is retained by ADP that is not indicative of a lease or a rental.
But at the same time, so I have a son, he's at college, He signed a lease for a rental. It's a little house. It's very nice. But that part of that document says, we own this stuff. You shall not put any nails in the wall. You shall not make any additions to the place. You shall not do, shall not, and because we own it. Does that mean it's not a lease? Does that mean that my son does not have exclusive possession and control?
Your Honor, there's a difference between the lease and rental of real property compared to the software as a service that we are discussing here. So that's what I would point you to, is the underlying transaction is a service transaction between ADP and the county. It's payroll processing services and other human resource management services.
Okay, well then let's change the scenario a little bit if that is meaningful. Let's go to the Peck case. Okay, so in Peck, it's laundromat, right? So you have machines, laundry machines, and people go in, they pay money to use machines, but the machines, they can't be altered. They're not owned. You can't, so I'm seeing a lot of the same corollaries factually that exist here, and Peck didn't have any problem saying that those are rentals. So can you address that?
Certainly. Your Honor, I liken it more to the Energy Squared, Bentley Dill, and Jones Outdoor line as opposed to Peck. So to me, it's much more like the billboard rental, right, in Jones Outdoor.
Before we get to the billboard rental, can you please address the Peck? Why does Peck not apply?
I think it's distinguishable because of the amount of services that are retained, or the amount of control that is retained by ADP.
But in Peck, the laundromat retains all control of the machine.
I'm sorry.
In the laundromat case, the laundromat retained every aspect of control. Every aspect.
Except for the fact that the user, does have to start it. They put the coin in, they decide.
And in your case, the user has to turn it on and punch in their security code. And then they enter, just like the washing machine, they have to put the clothes in. Here, the county has to put in their HR stuff in the system. I don't see how a control issue distinguishes Peck from this case.
Your Honor, I do think they are still different. What's happening in the...
Well, I know they're different. One's a machine and one's software, but...
I think even the process itself is different. So when you're looking at the laundry machine versus the simple login online to the server, all they're doing is entering, I worked 8 hours today, I took 4 of it was sick leave, tomorrow I have jury duty, so I'm putting in jury duty for next week. And then ADP actually performs all of the functions of the underlying contract, which is the payroll services contract. So the fact that the software is being used as a very, very tiny aspect of it, what you're asking for in Peck is you're asking for your clothes to be laundered and them to be finished at the end of it. Whereas here, that is not the end of the service, and that is not the end of the material that's being provided by ADP. So
not to oversimplify this, but in the laundromat case, I put the clothes in, I put my money in, and then the laundromat is doing everything. They're doing the washing, they're doing the spinning, and then I have to take the clothes out. I don't see control. The laundromat controls the machine, just like ADP controls the software. But it's still the people doing the input that is the same, isn't it?
In my mind, it's still different, Your Honor. But again, I know you guys don't necessarily want to talk about Energy Squared and Bentley Dill and Jones Outdoor yet, but I think when you look at the amount of services and overall control and what is being provided by the actual thing that's being contracted for, our case fits much more in line with the Jones Outdoor and the Energy Squared.
Except Peck is an Arizona Supreme Court case, right?
It is, but it is the earliest of the 4 cases on this matter. So we look to Jones Outdoor as more of the more current restatement of where the court is with exclusive use and control. I would like to touch a little bit on the Internet Tax Freedom Act and how that applies not only to the case against ADOR, but also to the City of Phoenix. ADP, as I mentioned, is a service business, and they have always been a service business. And you can probably imagine how in the past punch cards were used for employees to calculate their time, whereas now they've moved to using the software vehicle in order to fulfill those payroll services. The Internet Tax Freedom Act prevents the state or the city from implementing multiple or discriminatory taxes on processes or services, goods, even property, depending on the state's tax structure, that were not taxed before. They cannot now be taxed online. So we believe that that is dispositive of both the city and the state tax TPT with respect to ADP wasn't taxed as a service business when it was using manual punch cards, and now simply because they're using this online vehicle with the e-time software, they are now being taxed and that would violate the Internet Tax Freedom Act.
Hey, can we visit that just for a second and
Sure.
say, okay, so you're not suggesting that provision of services can never evolve, are you? I mean, that the nature of automation itself can change the very character of a business structure. You're not arguing that, right?
I'm not sure I understand your question.
Okay, so let's go back to the context of PEC then. And if you have a person that starts a business, it's a laundry business, and you hand them their clothes and you say light on the starch, and then they go and they wash all the clothes by hand and then return laundered clothes. You would agree with me that's a service?
Yes, Your Honor.
Okay, so, and therefore not subject to TPT. But now, let's say that person invents the washing machine, and now they use a washing machine to do all of those clothes. And PEC opens, in fact, a laundromat to do that. PEC clearly says that is a rental of TPT, so it's subject to TPT. So the nature of the business changes at some point, and as I see it, the significant difference between the two scenarios is automation. It's not use of the internet.
Your Honor, I would kind of go back to clarify. Obviously, I don't think there's anything in automation that would make something immediately taxable, but I think that's what the state has done here. So our services, and what you would describe was a laundrette service where somebody was doing the actual washing and they were starching, and that's what you were getting at the end. The way I read PEC is that it's an individual goes to the laundry machine and is doing their own laundry. It's not that they're having it serviced. There is a different, when you go to a laundromat, you can certainly have a fluff and fold service where you're actually paying somebody so that you don't have to sit there in front of the machine on your own. And I think that's what's happened here, is that it used to be a manual process. Now, with automation, it's moved online, and now the state is saying, and we want it taxable, whereas it would not have been taxable in the past because it was a service business and still is a service business.
So the fact that these processes, because e-time automates a lot of different things, right? So you don't have, for instance, the time collection matter, so aggregating and those types of things, that's all done by e-time. Calculation of withholdings and such is based off of algorithms that exist inside of that.
Your Honor, it's certainly based off the inputs, but I believe that that's done separate from e-time outside of it, that the e-time feeds into a different program that actually calculates all of the payroll.
Right,
and the
but
withholdings.
there are no such things as punch cards anymore, right? So but the point is that there's a significant amount of automation that has taken people out of providing these services. Is that not so?
There's automation that has made services more efficient, but I don't think that necessarily means that the legislature has said, and it's taxable. I mean, that's for the legislature to come back and say, yes, we agree with automation, and these services that used to be untaxable are now taxable because of the use of software. And I think if you obviously read the briefings, and I don't know if you had a chance to watch some of the videos on the ad hoc taxation committee, but the legislature said it's not clear in our statutes whether this is taxable right now, and that they were trying to make improvements for both digital goods and digital services to figure out what is taxable. And by the legislature itself admitting, essentially, that it is not clear, I don't think that a state agency should have the authority to come in and say, yes, automation means now it's taxable. I think that's something that gets left at the legislature.
Well, I'm not arguing with you that the legislature has total purview over what it is that they put inside these buckets. What I am saying, though, is that, I mean, what are we to do with that when it hasn't resulted in binding changes to legislation? I mean, PEC is from, what, the 70s?
76, I believe.
Okay, so, and the tax code has not been reinstantiated or had any changes made to it from 1976 to now? I believe it has.
Your Honor, it certainly has had changes to it, and I think that's one of the benefits here is that we know that it is a modernized, oft-reviewed, lots of public policy discussion surrounding when it's appropriate to tax or not tax something. There's been certainly lots of discussion over the last 20 years, and even into when PEC was established. The fact that they haven't done anything yet doesn't mean that the state agency has the ability to start taxing something that was never taxed before.
But it didn't exist back then. I mean, they imposed it, there's a tax, it's whether or not what you do fits within the tax code. And if it's not to fit within the tax code, it's the legislature should tell us it should fit. But they haven't done that either, have they?
Your Honor, what the legislature has told you is that this area of law is unclear.
No, they haven't. Where does that say? Could you give me a statutory cite for that?
It's not the statutory site, but it's the Ad Hoc Committee on Taxation.
Okay, well, that's not legislation.
Okay.
Until they pass legislation saying this doesn't apply, and if they did that, oh, boop, this is done, we're out of here, right?
Your Honor, right, but they have admitted themselves on a legislative record that this area of law with respect to taxation of digital services is unclear, and it lacks clarity and needs clarification. And they attempted a couple of times to pass bills.
But that's not binding on this court, and all this court has to look at is previous case law and apply it to an ever-changing, rapidly changing area of development, which is this great World Wide Web that keeps giving new technology and new issues. So if we're bound by prior case law and the ad hoc committee is not binding on this court, what are we to do? We can't remand to the legislature.
Your Honor, obviously you can't literally remand to the legislature, but you can certainly take judicial notice and recognize the fact that the legislature itself has stumbled over this issue and has not been able to, in its own mind, seek the clarity that is deserved by taxpayers. And I'll take you back to the case law BSI that talks about taxpayers need clear notice of what is taxable so that they may organize their affairs accordingly, and that just hasn't happened here. The legislature itself has said it's not clear. So I think what you are able to do today is to say, we agree that it's not clear, and we then in the BSI and capital castings line say.
Except we don't agree with certain legislators. The legislators act in a body, and until the body passes legislation, we're not saying, oh, we agree with this group of legislators that made a statement. That's not how we function.
Your Honor, obviously I'm aware of it. For us, it's a good indication. It's an indicia that the legislature itself has, as a whole, has struggled over this issue. I mean, the bills have made it to various stages. One of them did pass the House of Representatives, the entire House of Representatives. Certainly, it didn't pass the Senate and get the governor's signature. But we see it as an indication of where you can go to determine that this actually is an ambiguous statute and therefore should be interpreted in ADP's favor. And with that, I will reserve the remainder of my time.
Thank you, counsel. Mr. Teasdale.
I'm Scott Teasdale with the Arizona Attorney General's Office, representing the Arizona Department of Revenue. May it please the court. In this case, ADP seeks a refund for taxes it paid on its separate revenues from renting e-time software to Maricopa County. It began renting e-time to the county after the county, which had been using locally hosted PeopleSoft software with equivalent functions, had a renewal period come up, and then it decided to shop around and look for alternatives rather than pay apparently multi-million dollars in renewal fees for PeopleSoft. And they contracted with ADP for both HR services, and as part of those services, licensed the e-time software for their employees to use.
So, Counsel, you broke that out. So the ADOR is saying that they're acknowledging that there are components to this contract that involve services?
Absolutely. The HR services themselves, them doing the payroll, submitting payments for taxes, and so on, those are services. It is not unusual at all for businesses to have multiple lines of business. We see that both within the transaction privilege tax, where you may have 3 or 4 lines of business under different classifications, and then also businesses that are not under a classification. So there's no hard and fast rule that if you have a service business and then you also have a rental business, that you would not be taxed on the rental. Now, I think on this point that they cannot be also renting property. They also rent time clocks. That's in 8.4.2 of the contract, the same revenue section for the software. They did not bring a refund claim for TPT paid on time clock rentals. Well, that to me shows that they clearly acknowledge that you can be working in a taxable classification even if you are doing a service business. They have also suggested in their briefing, well, what if we gave it away for free as part of this larger HR service contract? Well, under the Advo Systems case at 189, Arizona 355 at 361, it says a taxpayer is not entitled to be taxed as if its business was structured differently than it actually is. That is standard in tax law. You can also look at Balthrope v. CIR at 356 F. 2nd 28 at 34, which says no one has to arrange his business affairs to satisfy the tax collector's appetite for revenues, but when a taxpayer has failed to arrange his affairs so as to minimize his taxes, he cannot expect the court to do it for him nunc pro tunc. This is not a case where the department went out and audited a taxpayer and had to determine, oh my gosh, is there actually a hidden rental here? They were reporting rental tax, and then they sought a refund. So the idea that this was some surprise, that the overreaching department was going after them, that is not consistent with the facts in this case. The department's view is that software is tangible personal property under both the statutory definition, which has survived with only minor modifications since the 1930s, and State v. Jones interpreting that definition in a criminal case in which the statute would have been given a narrow reading, and the court had no difficulty determining that the music coming out of a jukebox was tangible personal property.
So the argument is that Jones is both archaic and wrongly decided. What are we to do with that?
Well, it's Supreme Court precedent, Your Honor, and I don't know if I would use the term archaic. I think it's long-standing and solid and has not been overruled or significantly questioned. ADP then, of course, for tangible personal property, tries to rely on property tax cases and property tax statutes. But there's nothing that prevents the legislature from deciding we're not going to treat software as personal property or tangible personal property for property tax purposes while taxing it under the transaction privilege tax. Honeywell, we think, is bad law. It's fairly clear they didn't understand what software was. When you look at footnote 1 to that case, it's all services. The only thing in there that it was software at all was number 1 on the list, custom programs. We don't tax custom programming under the TPT. We view that as a service. If you hire a programmer to write a program for you, that's viewed as a professional service, even though it does generate software. But canned software, pre-written software that's being mass marketed, is treated as tangible personal property.
Well, I thought there was some tweaking for the software as it relates to Maricopa County. I thought they specifically altered their software for Maricopa County?
No, Your Honor, it's rather to analogize it. If you had business management software like QuickBooks and you wanted to pay checks out of your checking account, you would have to configure the software by putting the appropriate data in. So they do configuration work to set up all the employee classifications. That's a separate revenue item under the contract that they paid early on when they were setting this up. That's not included in the e-time fees. And those revenues for the configuration to set it up are viewed as labor inputs and are not taxed under the transaction privilege tax.
And they were not taxed in this case?
No.
So the refund they're requesting has nothing to do with the configuration as it relates to Maricopa County?
That's correct. It's simply the monthly fees for the software. It's got nothing to do with fairly substantial amounts to set the configuration up for Maricopa County.
Along that line, Counsel, am I correct in saying that as part of that maybe it's not even part of the configuration, but Maricopa County's account by which it accesses, it and its employees access e-time is unique to Maricopa, right? So the general public can't get into Maricopa County's employment data, correct?
That's correct. No one other than Maricopa County employees are using the e-time software that Maricopa County gets.
And I think ADP said in the record that that it has multiple clients inside of Arizona, including Pima County. Am I recalling that correctly?
That's correct. Pima County, and I'm sure many others. And the evidence in this case is that each of their customers has their own separate copy, which is only accessed by that customer. So Pima is not using the copy of the software that's on the hard drive that Maricopa has.
No, I'm going to push back a little bit because I think in the brief it was stated that none of these people actually have possession of a copy of software. Isn't that correct?
I don't think so, but it depends. The word possession has been the subject of a whole lot of case law over the years, and it's not quite as simple as having it on the machine. This is particularly true with software. If you download software, for you to obtain a copy, do you have to have it on the PC that's next to you? Can it be on a server somewhere else in the building? Can it be on a server that's in a data center downtown? Can it be hosted on a machine? Additionally, what you see on your screen, that is software. When you see a button that you click on to enter your data after you've typed it in, you are clicking on software functionality. If it was simply just a picture and you clicked on it, nothing would happen. There has to be part of the program sent over the internet to load onto the local computer. So it is both. Additionally, let me move to the possession section of my argument. The definition I cited was Merriam-Webster's, the act of having or taking into control. And here we view this as the manual controls, not automated functions running in the background, but the manual controls are used by the Maricopa County employees. The county gets its own copy, as we mentioned. Others can't log in and use it. So therefore, we do think there is possession. The case we cited for possession discussed both actual and constructive possession. Actual being defined as a person who knowingly has direct physical control over a thing at a given time is then an actual possession. So again, control and possession are, in at least some cases, synonymous. And here, using the manual inputs, we think is control. There is also constructive possession, and we have a state of Arizona case that says one who exercises dominion or control over a property has constructive possession of it, even if it is not in his physical possession.
Does it have any consequence if the servers are located in a different state and all of the data is stored in a different state?
No, Your Honor. The taxable act in the TPT is doing business in this state. And the Ensign case and the Southwest Kenworth case clearly say that not all attributes of the transactions have to be in this state if the business generating activity is with an Arizona customer or you're entering into the contract in Arizona. Both of those cases, particularly Ensign, relied on the concept of constructive delivery, which is also related, of course, to constructive possession. Ensign relied on it, and it was also mentioned in the Southwest Kenworth case. With regard to operation and control, notably here, we do not have ADP providing employees who are sitting down at the county opening e-time software and entering the data. That is performed by the Maricopa County employees. And we think that distinguishes the equipment with operator cases such as Bentley Dilley and the Energy Squared case. Those are clearly premised on the idea that if the equipment comes with a vendor-provided operator, then that equipment is to perform the manual functions to operate that equipment, then it is not a rental. And you could think of it the difference between renting a car or getting a car with a driver. And here, we don't have a driver. The Maricopa County employees are driving the software. Getting back to PEC, I think the panel is, getting back to PEC, I think the panel is entirely in the right direction on that. There are always going to be automated functions in modern machines. Automatic transmissions have computers deciding when to shift. That doesn't mean that the manual controls of the car aren't being operated by the customer, and does not render automated equipment, which is virtually all equipment these days, from being rented. The argument about the Internet Tax Freedom Act, the department treats software that is sold or rented to Arizona customers as taxable either under rental or retail, regardless of delivery method. You can buy it on a disk. You can download. There's a type of delivery called load and leave, where they bring over a tape, load it on your machine, and then take the master copy that they copied onto your machine with you. You can also rent software that is on a remote machine. In fact, if you rent a server, the server will almost certainly have an operating system, either Windows Server or Linux, preloaded on it, and you're renting that too. So, and that goes again to the issue of whether you have to have it loaded on a device that is physically proximate to a particular user of it. Now, I use software that's on our office network all the time, and I have no idea where the network software is located. I don't know if it's in our building, I don't know if it's at ADOA, I don't know if it's a server farm, but I'm still clearly using it.
Can you address briefly the issue of automation and the fact that HR services typically were services historically before the advent of computers and software, etc., and why the automation of portions of that has now taken it from a service to a rental?
I don't think it has. The service portion of the contract, what ADP does with data, is a separate line of business. It wasn't taxable before. It's not taxable now under the transaction privilege tax. What is taxable is rental of tangible personal property. So if before they were renting time clocks along with performing HR services, they would be rented, they would be taxable for the rental, but not for the other service. The fact that you add in a line of business which includes a rental or a sale component, what if they were selling time clocks? If they were selling time clocks, would that not be taxable under retail, simply because the data from that time clock then goes into their system and they provide service with it? So again, it's just a matter of having multiple lines of business. And we see in many of the tax cases where you can have a separate service line of business and yet have a taxable line of business as well.
But you obviously don't agree that e-time is a service, otherwise we wouldn't be here.
No, Your Honor. We view that as a software rental, simply using the modern technology, which ironically enough is very much like early technology. In the Babcock-Wilcox case we cited, it used to be very common to rent computer time on remote mainframe computers where you would rent both the software you were using and the mainframe time and access it through a dumb terminal, and that was treated as a rental. So we're essentially going back to a bundled product, a bundled hardware and software with hosted software, whereas for a long time it was disaggregated. I promised my co-counsel I was going to give him 5 minutes, and I'm to 4, so I will step down. Excuse me.
Thank you.
My name is Scott Anderson, and I represent the City of Phoenix. May it please the court. All of the arguments made by the department in this case apply equally to Phoenix, but most of them are not needed in order to find in Phoenix's favor. First, the argument about whether software is tangible personal property is irrelevant to Phoenix because Phoenix's city code, section 14115A, defines computer software and expressly deems computer software as tangible personal property. Second, the argument about whether ADP rented or leased E-Time software to the county is also irrelevant to Phoenix because the Phoenix City Code specifies that licensing computer software for use is subject to transaction privilege taxes. And in this case, ADP granted the county a license to use its E-Time software, placing it squarely within Phoenix City Code. And third, all of the discussion about the rules interpreting ambiguous statutes don't apply to Phoenix. The rules of using legislative history, impari materia, the doctrine of our harmonious construction of statutes, they don't apply to Phoenix because Phoenix City Code is not ambiguous. I would like to address the Internet Tax Freedom Act. That act prohibits Phoenix from imposing discriminatory taxes on electronic commerce. Phoenix's tax code does not violate the Internet Tax Freedom Act because the Phoenix City Code imposes the tax on all sales and licensing of pre-written computer software, regardless of the method by which title, possession, or right to use the software is transferred to the user. So, as Mr. Teasdale mentioned, the county had been using PeopleSoft, which is an offline HR software similar to the enterprise E-Time software. Both software is subject to TPT, even though they are transferred to Phoenix using different methods. In this case, ADP is trying to use the Internet Tax Freedom Act as a sword rather than a shield by asking this court to treat ADP's E-Time software differently than it does other software. In conclusion, ADP's gross revenue from licensing its software to Maricopa County is taxable under the plain language of the Phoenix City Code. That explains why ADP and Amici basically ignored Phoenix's arguments in their briefing. ADP is not entitled to a tax refund from the City of Phoenix. Thank you.
Thank you, counsel.
Thank you, Counsel.
Rebuttal?
Thank you again, Leslie Sorensen on behalf of ADP.
Can you start by responding to Mr. Anderson's argument regarding the clarity of Phoenix City Code in relation to the TTP?
Certainly. Yes, it's definitely a tougher argument for ADP, and we've granted that all along. However, we do disagree with their interpretation of the Internet Tax Freedom Act and believe that that would, regardless of how clear their law might be, would knock out the software as a service from being taxable under their code because of the violation of the Internet Tax Freedom Act.
Thank you.
Sir. Just a couple of points I'd like to respond to, Mr. Teasdale. First, we talk about the perception of the code and the software, and we're talking about the graphical user interface, the GUI, you have to actually perceive the code, however, for it to be considered tangible personal property. It has to be perceptible to the senses. And the function that might be behind something, the set of instructions, is not actually the code that you are seeing. You are not seeing the software itself.
Well, the response to that is from Jones, which is that you don't see the sound waves coming in, and yet the Supreme Court, our Supreme Court, held that that's what they're renting. So how is that different?
Your Honor, there was an awful lot of time spent in that State v. Jones opinion talking about the mechanics that were behind the actual playing of the music. But the music is perceptible to the senses. You can hear it. And although, again, we do believe it's archaic, it was decided under a different set of law. There was no TPT on leasing at that time. There's a lot of time spent on the mechanics of the actual jukebox playing the phonograph. And I just think it's kind of funny.
Why is a GUI not the same as the jukebox in that case? And then in which case the light organized according to the code or by the code through the GUI, why is that not similar to the jukebox playing airwaves?
Well, Your Honor, I just say that that is not software, and that is not a representation of software. That might be a set of instructions. You know, it's the binary impulses that Texas has said is not considered tangible personal property. The actual software itself is not perceptible to the senses. I think my time is done. Thank you so much today. Thank you so much.
Thank you, Counsel. Thank you for your arguments. We will take this matter under advisement and issue our decision in due course. The court is now adjourned.